because I was largely responsible for bringing Stuart Wheeler into a High Council's chamber, Leolin Price QC, back in, when was it, January of this year, to hear a presentation by John Bingley and others, people from Defenders of Far Sovereignty. And Stuart Wheeler was so impressed with what he had to listen to when John did his presentation that at the end of it, he asked Leolin Price, after a 2-hour session, what he thought the chances of winning were right up to the High Court if we brought a legal action. And Leolin Price considered it for a few minutes and said 50-50. With that, Stuart Wheeler said, "I'll go for it." A lot of what you're going to hear from John Bingley's presentation this evening, you will know certain parts of it. But where this presentation really scores is that it brings the bits together and connects the dots and gives you an overall cohesive view of where we are with this question of our sovereignty being given away and the failure of both the judiciary and Her Majesty the Queen to stop it. Yes. I think you'll find it interesting. It's a relatively long presentation, but there's a great deal to learn, and I think you'll also find the net conclusion quite shocking. I know that I did. So can I ask you please to welcome John Bingley.
Good evening, ladies and gentlemen. It's very nice to be here to have an opportunity to show you my presentation. I will just explain that I'm a layman and I've studied the Constitution out of my own interest and put together really a logical process from fundamental documents. And so what I've done is to try and lay clear what is the basis of our Constitution, and what you'll see tonight will be a lot of fundamental constitutional documents and a script to tie it all together. So let's begin. Firstly, it's necessary just to get a sort of basic idea of what we're going to be talking about. And we all wonder, we hear that we have no constitution, and many of these things are said, that there's no written constitution and so on. Well, our constitution has evolved over many centuries, and much of it is written, some of it is unwritten, but it's there and it's very important. And further, all those that hold office are of course contracted to it through their oaths of office, and therefore by the rules of our law. So the question comes, when we hear about the people talk about the sovereignty of Parliament, how far can that go? Are there any limitations, or are there boundaries which the people can rely upon to hold the executive and their government in check? And so therefore, that's the question. Has Parliament been accorded absolute power? Because obviously if it has, then constitutional limitation, there can't be any really that's of any real effect. And of course, conversely, if there is constitutional limitation, then it's plain that we ought to be able to get to it and seek redress and remedy if it's infringed. Well, there's one of our greatest documents worldwide, known worldwide, the Magna Carta 1215. There are 4 copies existing. This one is in Salisbury Cathedral and remains there from public view. And as we all know, it was there in 1215 that King John was forced to sign it at Runnymede in order to control and limit his power in favour of the people. Further, if we come forward to the 1600s, we have the Declaration and Bill of Rights. The Declaration is nearest me, and the bill itself is the one on the left there. 2 further constitutional documents about which we'll talk a little more later, but certainly there's much written constitution. So, Magna Carta, what did it do for us? Well, it's a presumption for liberty. Very important, presumption for personal liberty by limiting the power of the state. And it does so in an interesting and most important way by creating right to trial by your peers. So we don't live in a police state, we live in a state where the ultimate enforcement is at your peers, the local people who enforce, not the state. At least that is the theory. And of course it's a great and terribly important caveat upon the power of government, because it makes it very much more difficult if you have juries enforcing the law for a government to enforce or push on the people oppressive law, because a jury always has a right to declare a no guilty verdict, not guilty verdict. Obviously, if you've got a constitution, you need a right of redress and a right of enforcement. And all of those things were scripted within Magna Carta. This is the current statute version of Magna Carta. It was passed by Edward in 1297, and much of Magna Carta has been repealed as far as statute is concerned. The original charter remains, but the statute has been repealed in many places. But this most important caveat upon our governance is there. No free man shall be taken or imprisoned, or disseized of his freehold, or liberties, or free customs, or be outlawed or exiled, or anywise destroyed. Nor will we pass upon him, nor but by the lawful judgment of his peers, or by the law of the land. We will sell to no man, we will not deny or defer justice or right. And then it shall not be infringed or broken, it shall be of had no force or effect, so things that go against us. So it's very interesting. Lots of you who have been in any small court issues will not think there's much free about justice these days. But there was a principle, and that is still on the statute books. If we now fast forward to the 1600s, when the Declaration of the Bill of Rights came into our history, we need to realise that there was a revolution, a glorious revolution, and what had been going on under the divine right of kings, the Stuart kings in particular, was wanting to be tamed and curtailed. That, again, this was a question of the executive imposing power over the rule of law, and the king therefore assuming that he was above the law. As you know, William of Orange was invited over. He had a legitimate claim to the throne. His wife Mary was in fact the next heir, or legitimate heir, and James II was deposed. And this picture, this painting, is of William and Mary having deposed James, who fled the country, throwing the Great Seal into the Thames on his way out. And it was declared ultimately from the Declaration of Rights that he had abdicated. And what happened is that William came into power. There was an interregnum, so James fled on the 17th of December 1688, /9. And just a word about the dates of this time. It's quite interesting. The dates, the calendar was the old calendar, and so the year changed with Easter. And so January and February 1688, as we think of it, as they thought of it, was what we would think of as January and February 1689. And the year changed, in fact, Easter was on the 25th of March, I think, 1688-9. So what happened is that James fled the throne, or fled the country after William's arrival. He was actually caught and returned, but then sent away because William didn't want to deal with his father-in-law, and he fled to France. So William was left in charge. He then said, right, well, I'm here. I've not come to upset the arrangements, but just to try and put back in place what ought to have been the rule all along. And he said, how do you want to settle affairs? And called a committee. And this committee decided that there should be elections, which were duly held. And they decided to assemble a convention parliament. And so this committee, the convention, Revolutionary Convention, met on the 22nd of January 1688, and they deliberated, and they decided that James had done basically 13 things wrong. There were 13 ways in which it was to be put right, and that all this was to be put in a document, which indeed is the document in this picture. It is the Declaration of Rights, and they declared that James had violated the principles of the Constitution. He had fled the country and therefore abdicated the throne, and that William and Mary were the rightful heirs. So what happened is that this was enrolled, the Declaration of Rights, in the Chancery, and that was on the 12th of February. On the 13th of February, there was a handing over of the crown, which is depicted here in the banqueting house. And before the crown was handed over, the Declaration of Rights was read to them. And there you can see the Declaration of Rights in the Clerk of the House of Lords' hands, being read with Lord Halifax bended knee, offering the crown to William and Mary. So the idea was that the intention was that this was a conditional contract, so that they could have the crown, but under the conditions of the terms of the Declaration of Rights. The great thing about the revolution was it was a victory for the supremacy of the law and separation of power. It wasn't, as the left tend to think of it, as a victory for Parliament over the King. It wasn't. What was actually done, and this is the thing that's got lost in our history, is that it actually elevated the rule of law. Be ye king or commoner, the law is above you. And that was the whole principle. It didn't actually elevate it, it just made sure that it was back where it truthfully should have belonged. And so there was power limited by a contract between the people and the monarch to reaffirm the superiority of the law. It was not a victory for Parliament over the Crown or monarch, as it is frequently and usually portrayed. One of the proofs of this lies in the Bill of Rights itself. What happened is that William and Mary accepted the crown under the terms of their Declaration of Rights, and they came into the crown, and so it was decided that at a later stage that all this was likely to be queried. So they thought the best thing we can do is we've got this Declaration of Rights. What is it? We don't really have a proper Parliament. We didn't have a king. We've just deposed a king. We better do something with it. So they passed a Bill of Rights, and if you read the Bill of Rights, what it does is it cites within its text the Declaration of Rights. So that's how the two documents come into being. The Bill of Rights was merely a statutory enactment once a Parliament had been reassembled with a lawful king. There's an interesting thing called a grundnorm in legal speak, and a grundnorm is a point to which a state can trace back a true line from which a legal foundation has been built. So in many ways, this was a grundnorm, although in fact it was very much in line, and it is quite arguable that this was entirely in line with the enforcement clauses laid down in Magna Carta to assert the law over the government. Anyway, the proof of the fact that the divine right of kings wasn't actually defeated by the Bill of Rights as such and the Declaration of Rights is you can see that this red text here, and to whose princely persons the royal state, crown and dignity of the said realms, with all honours, styles, titles, regalities, prerogatives, powers, jurisdictions and authorities to the same belonging and appertaining, are most fully, rightfully and entirely invested and incorporated, united and annexed. Wonderful language, but you can see that it was fully intended that the crown should have all the rightful power that it had before, when the divine right of kings was in being, and it should be put down in writing like this in the Bill of Rights. And what did change everything was that James had denied that he was controlled by the statute law. And so when William and Mary came to the throne, it was decided that there should be a Coronation Oath Act, and that they would alter the Coronation Oath. And if you notice the red words at the bottom there, the statutes in Parliament agreed on. If you read the text, Archbishop or Bishop shall say, will you solemnly promise and swear to govern the people of this Kingdom of England and the dominions thereunto belonging, according to the statutes in Parliament agreed on, and the laws and customs of the same. Now the red words, statutes in Parliament agreed on, were not in the old oath. So this was the big change. Because suddenly now the Crown could no longer deny in any way, it was blatantly obvious, that it was controlled by the statute law. So a constitutionally limited monarchy, limited by custom, law and statute, and therefore clearly it's straightforward logical reasoning that therefore the Crown's prerogative cannot be used in repugnance to the law in force. And particularly the law that is aimed at controlling what the Crown can do, which is the purpose of the Bill of Rights and so forth. And so Royal Ascent is itself merely prerogative of the Crown. So I'm arguing that what the Crown can't do, in fact, Parliament can't do, and ought not to do. So there are the words. They had an enormous effect, of course, because this really gave birth to the rise of the British Empire, those words and that document, it's a wonderful thing to be able to go to the House of Lords Records Office and actually handle these original documents from that period. They're still there, beautifully preserved, and one can get them out if you're a serious researcher. And of course, you can see it there. So it's quite something, because that really changed the whole, gave rise to the free world. That is Elizabeth II's coronation oath, and her father's over on the far side. So it's still sworn and in accordance with the 1688 1689. Just so that you don't think this is entirely me making all this up, we'll go to one of our great commentators on law. He was Sir William Blackstone, and he said this about the settlement: however, in what form it soever be conceived, this is most indisputably a fundamental and original and express contract, and to reduce that contract to a plain certainty, so that whatever doubts might be formally raised by weak and scrupulous minds about the existence of such an original contract, they must now entirely cease, especially with regard to every prince who has reigned since the year 1688. So there you are, that's one of our greatest lawyers. So I thought, this is great, I'm very interested in this. Have we got a limitation to Parliament's power? They say they can do what they like, when they like. So I got my then MP, Howard Flight, to write a question. I asked him if he would ask a parliamentary question, and it was a written question, and we got a written reply, and he gave me the letters. And here they are. And what happened is that Downing Street, he asked it of Tony Blair, which is what I asked the Prime Minister at the time, back in July 2000. And you can see that it was delegated by Jan Taylor over there, on the left there, and Jack Straw was commissioned to answer this terribly difficult question for them. Could a minister recommend a breach of the Coronation Oath? I thought, let's ask that question. Could they recommend a breach of the Coronation Oath? Is there something that should limit them? And so we got back the reply there. I can confirm that the Coronation Oath is a solemn undertaking by the Sovereign and is regarded as binding throughout her reign. Her Majesty would not be advised to give her assent to a provision which contradicted that oath. Well, that was terrific. I thought, wow, marvellous. We got ourselves here a firm limitation. Where can we go from there? So it was then necessary to give a bit of study to the Coronation Oath Act. And we saw the red words imposed on it earlier on. Well, this is the beginning of the same scroll. And it's very important because at the beginning, the preamble tells us why the Coronation Oath is taken. And of course, you can see if you look at the highlighted words, it's basically there to maintain the statute, laws and customs of the said realm and all the people and inhabitants thereof in their spiritual and civil rights and properties. Well, to maintain us in our spiritual and civil rights and properties are very important. It's not to diminish them, it's not to give them away, it's to maintain us. So that's the fundamental purpose for which we are governed. And of course, the second promise of the Coronation Oath is very important indeed. Will you at your power cause law and justice in mercy to be used in all your judgments? Well, if you're starting to put this all together logically, you can see we've got the Crown now bound by the law, and they cannot use repugnance in contravention of the law. And clearly, the next promise of the Coronation Oath confirms it, saying that only law will be used in all judgments. King or Queen, I will. I will perform and keep, so help me God. So that's the additions to the Coronation. Next turns into our friend the Lisbon Treaty. So again, we were all pretty worried by that, and thankfully not from, we were all thankful to Ireland for what's gone on. But remember that I said everybody takes an oath of office, including our Privy Councillors, and there was some black text. Well, it's worth a look at that, because remember this has all been done by our Privy Councillors, acting on behalf of the Queen, in theory at least. And part of that Privy Council's oath is this bit of black text. You will to your uttermost bear faith and allegiance unto the Queen's Majesty, and will assist and defend all jurisdictions' preeminences. Think about that, as there's the Oxford English Dictionary below. Highest rank of distinction, priority of place, precedence, superiority. So it's quite clear. Jurisdictions, preeminences and authorities granted to Her Majesty and annexed to the Crown by acts of Parliament or otherwise against or foreign princes, persons, prelates, states or potentates. And of course a potentate is a powerful state or body. Well, the EU must surely rank as a potentate. I believe that Ken Clarke was disturbed by this and actually got some legal opinion from somewhere when he swore to becoming a Privy Councillor. What happened with that, I don't know. But I'd be very interested to know the detail of it. Coronation Oath, very important. The internet's a marvellous thing. A friend of mine was searching through one day and he discovered this for £7. And he said, I better buy that for John. And promptly bought it and sent it to me, which was very kind indeed. And there it is. It's an actual line print from the 1750s. And I can't read the small print without putting my glasses on, so you'll have to just excuse me. But the Clerk of the Crown reading the Bill of Rights, well, of course, it's actually a declaration, to the Prince and Princess of Orange in the banqueting house at Whitehall, previous to the offering of the crown. So you can see this was done for the Earl of Huntingdon, and it was highly thought of in terms of constitutional documents, such that somebody should, 100 years or so later, or 3/4 of a century later, have that nice line print made up. Now then, come 300 years, the tercentenary anniversary, there was a great party held for all our Commonwealth heads of governments and so on in Westminster Hall, and the Queen attended, and she made this speech. Experience has taught that peoples can enjoy the full fruits of liberty, security and justice only when they are represented in a sovereign legislature whose laws are interpreted by an independent judiciary. The Bill of Rights and Scottish Claim of Rights of 1689, still part of our statute law, are the sure foundation, look at those words, the sure foundation on which the whole edifice of parliamentary democracy rests, and it's had great influence abroad, especially in the United States of America and the Commonwealth. So it's very interesting. Here's the monarch supporting the whole thing in 1988. And guess what? He even struck a £2 coin for the occasion. And there's a little presentation set of the £2 coins. There is a silver coin, which very kindly a lady who's in this room from UKIP offered to give to me, but I couldn't do that. But anyway, that's it. It's the Bill of Rights was a silver coin struck as with the Scottish had a declaration of rights of their own, which they called the Claim of Rights, and there was a Scottish Claim of Rights, and there it is, and that was the coin for that. So there's a pair of coins, and there's the other side of the coin set, the £2 coin set with the Bill of Rights. And interestingly, in the top left-hand corner there, you can see a document with a splodge of ink on it, and that was actually a draft of the Declaration of Rights on which Clarke spilled the ink, and you can see there the ink splodge. But it's interesting that at the time they held that up as being the Declaration of Rights. In fact, we got the whole document beautifully maintained there. I'm holding it over the side, so the whole full document was actually available, and it was just wound up at the bottom. Anyway, there we are. So that was the fundamentals of what happened. So I then thought, well, if we've got some limitations to Parliament's power, it would be worth looking in Parliament's very own handbook to see what we can find in that. And of course, if we look through, I found this in Erskine May. The Act of Settlement affirms that the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws, and all their officers and ministers ought to serve them respectively according to the same. The Succession to the Crown Act 1707 declared it high treason for anyone to maintain and affirm by writing, printing or preaching, so it was high treason to write, print, or preach that the kings or queens of this realm, by and with the authority of Parliament, are not able to make laws and statutes of sufficient force and validity to limit and bind the Crown. Think about that. To limit and bind the Crown and the descent, limitation and inheritance and government thereof. Nor was this a modern principle of constitutional law established for the first time by the Revolution of 1688. If not admitted in its whole force so far back as the Great Charter of King John, it has been affirmed by Parliament in very ancient times. This is very important. There you've got a document, a statute, saying that this is high treason just to deny that the law binds the Crown. So, although that high treason penalty has been repealed, the principle remains, and it's been declared. It was only repealed by what was called the Statute Law Reform Act in 1967. The Statute Law Reform Acts were just there have been several of them, and what they've done is they've had these acts and they've removed from the statute book acts which they thought to be obsolete and out of date in order to clear up the statute book a bit. But what it actually says on the Statute Law Reform Act is it doesn't alter, it won't affect any of the fundamental principles, although we're repealing this lot, it's just to get them out of the way of the statute book. So it's even arguable that to some extent this is still the law. But certainly the principle, which is what I'm concerned with, is clear. That the government is bound by the constitutional law. And it goes on. Here's the Act of Settlement itself, which is referred to there in that speech. And again, and whereas the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same, according to the said laws, and all their officers and ministers whatsoever, ought to serve them respectively according to the same. I'm sorry, it doesn't say whatsoever here, it does in the Bill of Rights, I got my wording well. But anyway, it's totally inclusive. And that is current statute law. Now, our cabinet members are all privy councillors, and they take an oath of office. I won't go into the detail of it there, but notice the little bit of black text that I've highlighted. Parliamentary, all our MPs, there's a parliamentary code of conduct, and that says, by virtue of the oath or affirmation of allegiance taken by all members, when they are elected to the House, members have a duty to be faithful and bear true allegiance unto Her Majesty, the Queen, her heirs and successors, according to law. Members have a duty to uphold the law and to act on all occasions in accordance with the public trust placed in them. And it took me about 10 letters to get a little bit at the bottom from the Lord Chancellor's Department, but eventually they agreed. We agree that we're all subject to the rule of law and that it is a fundamental and essential principle of democracy. So I think that I'm putting in place the fact is that the Constitution is what ought to be all-powerful, and that Parliament is a component part of that. Our Constitution does not empower Parliament with unlimited or absolute power. Upholding our Constitution is the preeminent public duty of all who hold office, and therefore it should obviously be always their certain policy. So we ought to be able to rely upon our Constitution as having the overall binding force for our benefit. And the people's liberty is upheld at the discretion of their juries. Well, we mentioned that earlier on, and that's terribly important. We mustn't get away from it. Of course, a constant drive by the administration to separate the people from their courts, because the administration is always trying to accrue power to itself so that it can do the enforcing. And so more and more things are being hedged away, and the juries are being pushed into the back of the proceedings. Perverse verdicts, of course, are the ultimate common law proof of the limitation of statute law. Well, as we said, a jury always has a right to declare a not guilty verdict. And probably one of the most famous ones actually has its anniversary today. William Penn, on the 5th of September whenever it was, it's 337 years ago. He was tried, and the jury threw out the case saying that the law was wrong. So more recently, of course, we had the Ponting trial in about 1999-2000, where a civil servant had broken the Official Secrets Act But again, the jury refused. He was clearly guilty. He undoubtedly spilt the beans to the public, but the public decided, or the jury decided, that no, this was in the interest of the public, and the state shouldn't be trying to keep these things secret. It was all to do with the spy catcher stuff, you may remember, and the Ponting trial. And again, there was a not guilty verdict. So there was a not guilty verdict as far as he was concerned, overriding that law. And so redress and remedy are mandatory and integral to our constitution. Well, obviously, if government starts placing things in that are unconstitutional, it must be that we must have a means as a people to get to our constitution. And of course, the jury is an essential check on power. So anybody that's wanting to slowly condition us away from that will want to get rid of our right to trial by jury. Interestingly, going back in history again, this is the earliest act that I've handled, and it's an act against poisoning in 1531. And if you were the Bishop of Rochester's cook, this is rather relevant to you. His name was Richard Rose, and he cooked up a meal which poisoned 17 people in the Bishop of Rochester's palace. And indeed, there's a plaque there, I believe, commemorating this. And anyway, 17 people were badly poisoned, and 2 of them died, I think. One was called Alice Trippett, and her name is in this act. And Henry VIII was very worried about poisoning. He thought it was a very dastardly way to be carried on. And so he had an act against this poor chap. Whether he did it deliberately or not, I don't know. But anyway, it said that one Richard Rose shall therefore be boiled to death. And he was indeed, as you can see from the text below. I have a set of parliamentary histories which are old, they date from 1751. And in the text there it said, all mentions another act, that those who poisoned any person should be put into hot water and boiled to death. This was made at sea because one Richard Rose in the Parliament time had poisoned diverse persons in the Bishop of Rochester's palace, for which fact he was duly boiled to death at Smithfields. So it's pretty nasty. So you didn't want to be Richard Rose when that act was passed, and he was, of course, boiled to death. But what happened was that we had our revolution and we had our Declaration of Rights, which was enacted by our Bill of Rights. And one of the things they did was to stick this clause in there, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Well, the Crown was handed over. If you read the text of the Declaration of the Bill of Rights, you'll see perfectly plainly that it expects that to be fully obeyed at all times, forevermore. The Americans have a constitution. If we ask a man in the street whether we've got a constitution, everybody says, oh no, we haven't got a constitution, or we've got no written constitution. But, well, the Americans got something, haven't they? They've got a constitution and it's written. Well, there's their fundamental Bill of Rights. And guess what? They copied parts of ours and built it out of exactly the same tools. Oaths of office, rules written down as law so that they were known and declared beforehand so that people could observe and abide by them and know where they stand. And so therefore you can see the 2 bits, they're identical. Excessive bail shall not be required, or excessive fines imposed, or cruel and unusual punishments inflicted. And there are more clauses that are copied, and the principles are all there in the American system. Well, come 1803, there was a conflict in the courts in America in a famous court case called Marbury versus Madison. And what happened there was that Justice Marshall declared that in such a conflict between Congress, who had passed a law which violated the constitutional law, he said that the Constitution must always take precedence. And so Section 13 of the Judiciary Act, passed by Congress in 1789, was found to be unconstitutional and thus invalid. Well, that's very interesting because it was all built out of exactly the same principles as ours, but we've never had a Marbury versus Madison. And guess what? That case has never ever been put to the test. There has never been a fundamental test about the sovereignty of Parliament. It is all presumed. And it doesn't exist. Believe you me, the rule of law is above it, and I'm sure that one day it will be proven. And of course the Americans copied another clause there, the clause to petition the government for redress of grievance. And there is a right of petition to the Crown to call for redress of grievance. And the Crown, I believe, is compelled at this law, to abide by it. If we come forward again to 1929, we had a sitting Lord Chief Justice at the time called Lord Hewitt of Bury. And he was a very interesting man. And one of the things that he did was to write this book, The New Despotism. And he was very concerned that Acts of Parliament were being passed at the time, which delegated power to a minister to make such rules and regulations as a minister might like within the power of this Act. And that the words that the minister would use would be as if they were part of the Act. So these clauses were being put into an authorising Act. And then the minister would go away, and if you fell foul of it, whatever the minister said would in effect have the words of force of law. And so what Hewitt was saying was that this is wrong. What we're doing is we're now delegating lots of authorities around to our ministers, and they're getting, in effect, the force of law. And therefore what we're really doing is licensing lots of despotism, or lots of despots. And so that book caused quite a stir, because he was sitting Lord Chief Justice. Chapter 4 was called Administrative Lawlessness. Well, you can see that didn't go down over well with the establishment. So they thought, well, we better do something. So they had a committee of ministers' powers to sit and review what Lord Hewitt had said. They invited him to come on it, but he said, no, it's all in my book, I published, and there it is. And a Ministers of Powers report actually said, well, Parliament can do what it likes, it's sovereign, and it cited, this is how I found out about it, it cited the boiling to death of the Bishop of Rochester's cook, Richard Rose, as an extreme example of Parliament's ultimate power to pass any law it likes. And it forgets the Bill of Rights. It makes no mention of it in the thing. Now, from the Minister of Powers report, stem directly, we move up to statutory instruments. But in the report is a great piece of text which was taken from another report by Macmillan. And I'm going to read it because I think this will resonate very widely with most of you. The most distinctive indication of change in the outlook of the government of this country in recent years has been its growing preoccupation, irrespective of party, with the management of the life of the people. A study of the statute book will show how profoundly the conception of the function of government has altered. Parliament finds itself increasingly engaged in legislation which has for its conscious aim the regulation of the day-to-day affairs of the community, and now intervenes in matters formerly thought to be entirely outside its scope. This new orientation has its dangers as well as its merits. Between liberty and government, there is an age-long conflict. It is of vital importance that the new policy, there you have it, ladies and gentlemen, it is just a matter of policy, while truly promoting liberty by securing better conditions of life for the people of this country, should not, in its zeal for interference, deprive them of their initiative and independence, which are the nation's most valuable assets. Well, I think we can all agree that that's a wonderful bit of text. The report, the Minister of Powers report, concluded that the goings-on were a little bit out of order, and therefore ministers shouldn't be given such a free hand by the Enabling Acts, and everything should be written down. And so that eventually we trundled on from 1932, from the time of the report, to the Statutory Instruments Act in 1946, I think it was, yes, 1946. So that report gave birth to the whole system of governance by statutory instrument. Well, virtually everything we do now is statutory instrument. And it's interesting that you notice that it's got on its title page there, notes subordinate legislation. So relative to our Constitution, it's quite plain where all of these instruments, statutory instruments, and so on stand. Now this should interest all of us very greatly. When the Queen decides to grant Royal Ascent, she doesn't rush down to the Houses of Parliament, as people think, and sign the document. She commissions her cousins, so-called. They're not her cousins, in this case it's Lord Hailsham, but it's an ancient tradition. And she authorises them to grant Royal Ascent on her behalf. And what you have here is a letter patent signed by Elizabeth at the top left. The black splodge, I'm afraid it's a photocopy. I had difficulty trying to get hold of this all together. But anyway, the black splodge at the bottom is actually the Great Seal of England, which is put on it. And what this is a letters patent authorising the said people to pronounce the Royal Ascent to the acts on the schedule. Well, the middle act on the schedule of that schedule is the European Communities Act 1972. So here's another bit of paper that's rather relevant to us, because that is how the European Union, the EEC as it was at that time, got our Royal Ascent. It's there through a letter patent. There's a very interesting bit of text in the letter, and it again goes to prove my point about where power lies. The power was always vested with the Crown, and the two houses of Parliament advise the Crown for its use, and the Crown must have, if it has a right of assent, it's got a right of refusal. Anyway, you can see here it says quite clearly, the acts set forth in the schedule here too. The said acts are not of force or in effect in law without our Royal Assent. So it's quite clear that the Royal Assent is where the power comes to turn a bill into an enactment. And again, this adds strength to my contention that, of course, Parliament cannot do what the Crown cannot do. And, of course, the statutory instruments have come along and moved through. The administration has got bolder and bolder. And eventually we get to a point where we think we can actually just, Parliament is totally sovereign, that's now accepted legally, and therefore we can sign up for a new constitution with Europe and look at Article 10, Union law. The constitutional law adopted by the Union's institutions in exercising competencies and conferred on it shall have primacy over the law of the member states. Well, of course, it then gave itself in the text power over the competencies. This, of course. Again, I've been talking about constitution. It's not just me. William Pitt, Earl of Chatham, one of our great heroes of the 1700s, that to say if the Commons had passed an unjustifiable vote, it was a matter between God and their own consciences, and nobody else had anything to do with it, was such a strange assertion as he'd ever heard, and involved a doctrine subversive of the Constitution. What if the Commons should pass a vote abolishing this House, abolishing their own House, of course he was in the Lords at the time, and surrendering to the Crown all rights and liberties of the people? I'd just like to point those words out. And surrendering to the Crown all rights and liberties of the people. Well, that is very interesting wording, isn't it? Because it's quite clearly saying that there are rights and liberties that are no business of the Crown at all. They belong to us, the people. They're our birthright, and they're not there to be taken away. Surrendering to the Crown all the rights and liberties of the people. Would it be only a matter between God and their own consciences? Would nobody else have anything to do with it? You would have to do with it. I should have to do with it. Every man in the kingdom would have to do with it. And every man in the kingdom would have a right to insist upon the repeal of such a treasonable vote and bring the authors of it to condign punishment. I therefore again call upon the noble Lord to declare his opinion, unless he will lie under the imputation of being conscious to himself of the illegality of the vote, and yet being restrained by some unworthy motive from avowing it to the world. Lord Mansfield replied not. Anyway, that's a fairly interesting piece, and of course that's really where we are. The Constitution clearly places supremacy in the law, not in Parliament. The Coronation Oath is the contract by which we must be governed. It secures the supremacy of the law over Parliament and the Crown. Certainly our constitutional law does. And the Coronation Oath is undoubtedly part of that. To pass powers of governance to those who owe no allegiance to the Crown and thus the people is unconstitutional. Are unaccountable to and elected by and not removable by the electorate of the UK must also be unconstitutional. The acceptance of the supremacy of EU law is a subordination of our constitution to a foreign power. How does that tie in with the Privy Council's oath of office? To accept the supremacy of the EU law, the Queen will of necessity have to renounce her coronation contract to facilitate the dismantling of our existing constitution or be put in breach of her oath. Well, that's certainly my view about the principles that I've demonstrated to you so far. There's some interesting court cases and, on the Bill of Rights. Back in 1910, the budget failed, And one Mr. Bowles had a very large dividend. I think it was about £30,000, so he was a very rich man in those days. And the taxman came along and said, "Oh, well, I'm coming to take your dividend for taxing." And he said, "Not on your life, you haven't got a budget. You can only take away from me by Act of Parliament." And it went to court. And the judgment was this: the Bill of Rights still remains unrepealed. Their practice or custom, however prolonged or however acquiesced in on the part of the subject, can be relied on by the Crown as justifying any infringement of its provisions. Well, the Bill of Rights, of course, has no taxation without representation is effectively one of its clauses. It says that the Crown cannot tax without an Act of Parliament. So Mr. Bowles won his case, so that's a very interesting one. And then there was another case that I point out here, which is rather interesting one, Congreve versus the Home Secretary with Lord Denning. Mr. Congreve, I believe, is the Queen's solicitor. And when the colour television started coming into being, you could get we all had television licenses originally, which were just for black and white television because there was no colour. And then colour started coming on the scene, so they thought, oh, well, we can get some more money out of people for that. And a television licence cost £12. And so they decided that what they'd do is call an ordinary television licence a black and white licence, and that you then have to pay £18 to have a colour licence, as they knew everybody was going to get to their greater, they were going to recover more money by the colour televisions, obviously, as the prices came down. Anyway, of course, what happened is that Mr. Congreve very sensibly went out the day before the change and bought a television licence for a year. And the Home Office wrote to him and said, "Oh, sorry, old son, you owe £6. That changed, and now you've got to backdate that because you can't have a television licence for a year now, so you need a colour television licence." And he said, "No, I don't. I've got a perfectly good licence that's valid for a year." And so this was taken to court, and he won. And Lord Denning put this wonderful statement in: "There is yet another reason for holding that the demand for £6 to be unlawful and made contrary to the Bill of Rights in an attempt to levy money for the use of the Crown without the authority of the Parliament, and that is quite enough to damn them." So that's pretty heavy stuff. Interestingly, the House of Commons, the parliamentary privilege, which of course protects our MPs and what they say in the House, is one of the items listed in the Bill of Rights. It's one of the clauses. So guess what? When an issue arose about a parliamentary privilege, this was said by the Speaker in the House. The question of parliamentary privilege had arisen in a now well-known court case, Pepper versus Hart. Madam Speaker, the Bill of Rights will be required to be fully respected by all those appearing before the courts. This privilege is confirmed in the Declaration of the Bill of Rights, 1688-9, and what has become known as Article 9. So when it comes to a matter of parliamentary privilege, of course, they're only too keen to uphold our Bill of Rights. Further, in 2006, some asylum seekers had to be let out and in prison, and one of Blunkett's laws had gone west of it, and this arose in the papers. Lord Wolfe was asked what would happen if there was a clash between parliamentary sovereignty and the rule of law. His sober answer was that the question ought not to be asked. Look what the reporter says, but it must be. The issue of deportation is a potentially fatal fault line in the Constitution. Well, that I don't agree with because I have a different understanding of the Constitution, I believe. But there it is. Why are our top judges, or one of them, saying that it ought not to be asked? I think it most certainly ought to be asked. Going back to Lord Hewitt's book, he made a lovely bit in that, a little passage there which I'll now read to you. But how far more attractive to the ingenious and adventurous mind to employ the one to defeat the other. What he's talking about here is the ability of the administration to keep making rules and regulations and orders and so on, to defeat the rule of law, which was the fundamental from our Constitution, which protects our liberty. And so he's saying that this constant wedge, his complaint was that the administration is always trying to separate the people from their cause. So, but how far more attractive to the ingenious and adventurous mind to employ the one to defeat the other and to establish a despotism on the ruins of faith. It is manifestly easy to point to a superficial contrast between what was done or attempted in the days of our these wise kings and what is being done or attempted today. In those days, the method was to defy Parliament, and it failed. In these days, the method is to cajole, to coerce, and to use Parliament, and it is strangely successful. The old despotism, which was defeated, offered Parliament a challenge. The new despotism, which is not yet defeated, gives Parliament an anaesthetic. The strategy is different, but the goal is the same. It is to subordinate Parliament, to evade the courts, and to render the will or the caprice of the executive unfettered and supreme. Well, that's quite a warning. Now look at the topical issues that cross our constitution today. Trial by jury, currently in paper, so they were European arrest warrants and so on. Presumption of innocence. Intent is the central piece of justice. Not that strictly whether we're doing 31, 32 miles an hour, that might suit administrative proceedings, but intent is the central part of our common law system of justice. The right of self-defence. Well, it was the farmer, Tony Martin, of course. A Ministry of Justice. I think this is absolutely insidious. I think it is conditioning for us for corpus juris. It must be got rid of. If you think about it, it's an absolute anathema, isn't it? How can you have a Minister for Justice? That happens in police states. It doesn't happen in states where there is people power through their juries. Depends, of course, precisely what his remit is. But anyway, so a Ministry of Justice is something we should be very, very wary of. The House of Lords Supreme Court. How is that keeping in line with the custom? The House of Lords is the High Court of Parliament. That's what it is. How can the Supreme Court be? And that is going to ties in with the Ministry of Justice, because now you have something that isn't in Parliament, but is outside Parliament, and is of course not customary. So the Supreme Court allows for no appeal into the House of Lords, and to that extent I've been advised is again unconstitutional. ID cards, how's that maintaining our liberty and our freedom? DNA, of course. Emergency powers, well, we've all heard much about that for those of us who have looked through these horrendous powers that the governments have started to give themselves. Administration, of course, is excessive. We're being managed in every way. Devolution. The Scottish Parliament, when at the time of the English Parliament and the Parliament of Scotland, gave themselves up to become the Parliament of Great Britain in 1707 with the Union. And of course, British Parliament, or the English Parliament, accepted Scottish MPs and Lords into our Parliament. Well, with devolution, Scotland was asked, but we weren't asked. Interesting point, we never hear about it, but so we know the results of it, and we hear people talking about the results of it. Fishing, what about our poor fishermen who have had all their fishing so hampered by the EU? Fox hunting, how is that maintaining liberty? The right to roam, well, the landowner given no compensation. Well, the quid pro quo of the idea that you could start interfering with an Englishman's home as his castle, that the only way that the state was in theory able to start depriving him of his property was through where he had acted unlawfully, or the quid pro quo was that there would be compensation. Well, there was no compensation. Alternative medicines, of course, have come into an enormous attack with regulations, and of course the art market has been hit by the VAT and the copyright laws. So there are lots of topical issues. You'll probably know many more issues. And finally, the final screen, to our great man, Mr. Churchill, and when referring to Magna Carta, and when in subsequent ages the state, swollen with its own authority, has attempted to ride roughshod over the rights and liberties of the subject, it is to this doctrine that appeal has again and again been made, and never as yet without success. Thank you very much.
Absolutely typical.
I'm very pleased to answer any questions if anybody's got any. I think John's gone on. It's a bit hard of hearing, so I don't know whether we've got a microphone that can be passed around. I don't think we have.
I'll probably pick you up, and if I can't, I'll come down to you, but I should be able to hear most people. I'm just seeing if we've got a mic here. Yeah, these mics are working. I think you probably found that quite interesting, didn't you?
Oh, yes.
Nigel was so impressed when he heard this presentation that he had John flown down to Strasbourg to do it to all our MEPs, which he then did. I forgot to mention to you earlier that when John gave most of this presentation in Leolin's Price chambers, it was on that basis, or this basis, the Constitution, that Stuart Wheeler asked Leolin whether or not the case could succeed, upon which Leo said yes, 50-50, all the way up to the House of Lords. For whatever reason, Stuart decided to go with the QC, Rabinder Singh, who just coincidentally happened to work in Matrix Chambers, where our dear friend Cherie Blair works, and he took the case. But he didn't go on the constitutional challenge. He went on the basis of legitimate expectation, which is to say that because it was a Labour Party manifesto promise that they would give a referendum, that was in law a legitimate expectation, and that's what the case was based on. It succeeded in the court of first instance, and we got a judicial review, but the judges in that judicial review decided that the government had the power not to give a referendum, and therefore Stuart lost the case, and he was denied the right to appeal in the Court of Appeal. So that was the end of the matter. A very brave attempt, a very expensive one, but one that was very interesting, but it should have been based on the basis of this constitutional challenge here. So if there are any questions, ladies and gentlemen, gentleman there with his hand up in the air.
I've got several actually, but the first one is, why did Stuart Wheeler choose not to go with Leo Price's line? It seems to be much sunny.
Very good question. Did you get that, John? Why did Stuart decide to go with the challenge for legitimate expectation instead of this?
I don't know.
Don't use the mics.
We're having fun here. The answer is I don't know. It was all agreed, and the whole thing was going ahead on the basis of constitutional challenge. And the outcome was that there was a meeting which I didn't attend, and in which the whole thing was transformed into this different case. I was very sad at that, because I thought once I got Stuart Wheeler, I thought this is terrific. We've got a chap who's got the financial clout to push an attack through on this basis. I think I sincerely believe that if I had £5 or £10 million to go through the courts continuously, pushing them back to the rack of first principles, eventually these principles will come to the fore. And it's worth noting that if any of you are students of the law, and don't take me as I'm a layman, but if you're a jurist in any way and want to look, the Countryside Alliance case of the fox hunting, and there's quite a lot of comment in that about the possibilities of, and the judges saying that, well, maybe we've not got the absolute sovereignty of Parliament, maybe there is a chink in the armour. Well, I think there very definitely is a chink in the armour, and I hope that I've helped point it out. I'd like to take more cases. I was instrumental prior to this with the challenge with Norris McWhirter in the Nice Treaty, and during the course of that challenge, we went for judicial review, and the High Court refused us a judicial review over the treaty-making power of the Crown, and so we were then left with challenging that decision to refuse judicial review. So we got our judicial review in the appeal court, and we attended, and of course the case couldn't really be heard. It was about appealing the right to have the case heard. But during the course of that case in 2003, Lord Justice Pill, Leonard Price was acting for us, leant over the podium and said, "Mr. Price, I hope you're not going to impugn the sovereignty of Parliament." And Leo rather hedged his bets, and I'm afraid that's where that case went down. He could have dived in there. And subsequently, afterwards, when the meeting that happened with Stuart Wheeler, which we're talking about, I said to Leo during the meeting, I said, of course, we're going to have to attack the sovereignty of Parliament on this basis, on what you see. And he said, yes, I'm sure we will. And so I think once bitten, twice shy, and I loved Mr. Price to being able to have a crack at it. Sadly, it wasn't to be, but there are plenty more chances yet.
Interesting to note that the government had 2 leading barristers with 5 junior barristers. Stuart's side had 1 barrister with a junior. Talk about David and Goliath. Torquil, you had a question. Shout it down.
I have to hold the thing because you try something. Yes, I have a question, and I would also like to just make a few remarks, if I may, contrasting our history, which we've had a brilliant expose here, of the British Constitution, with what was happening at the same time as Magna Carta, Bill of Rights, in continental Europe, where I've been living for nearly the last 40 years. While we were having Magna Carta, in Rome they were inventing the Holy Inquisition, and in fact the Pope at the time was furious. Innocent III, as a professor of law, of the history of law in an Italian university, who dug out some letters that the Pope wrote to the English bishops and abbots who signed Magna Carta, telling them they'd done something abominable and illicit. And this is not surprising, because the Inquisition was the instrument of despotism. And then when we were having the Glorious Revolution, and we had the Civil War and cut off the king's head, in France they had the king saying, "I am the state, the Sun King," absolutism. And then when they had a revolution, some years after us, and cut off their king's head and thousands of other heads at the same time, they ended up with an emperor. And we had to have another war. An emperor who was practically just as despotic, and who also gave them their present laws of continental Europe, which do not. They did not overturn the Inquisitional principles, because the great invention of the Inquisition was to unify the prosecutor and the judge. Before, in the ancient Roman Republican system, there had been separate entities. You had the defender, you had the accuser, and the judge was the third party. And I did want to just say a few words, because I think it's very important for us to understand that what is being proposed is not the fusion of the United Kingdom with the rest of Europe, is not a fusion of like with like. It is a fusion of 2 totally different traditions and ways of thinking and systems of law. The supremacy of the state is unquestioned. The mere concept of limiting the power of the state is something totally foreign to all debate in all countries of the continent. The only dispute there is who is going to control the state.
Okay.
That's what. All right. Well, the question is about the categories. I wanted to focus. Just remember, and the question will come out of that. The laws and Crane. When they overturned, they didn't overturn. When they upheld District Judge Bruce Morgan's shameful verdict that convicted innocent men, the metric martyrs, for selling a pound of bananas and gave them a criminal record. They upheld that conviction. And at the same time, they said there are 2 sorts of constitutional law. There are 2 sorts of law. There's the constitutional statute and the ordinary statute. And there seems to be some convergence with what you've been saying, but I'd like your comments afterwards. They said that the Constitution, that the non-ordinary laws can be implicitly repealed under our old rule by subsequent legislation where there is a conflict. The later law repeals the earlier, even if it doesn't do so expressly. But they said constitutional laws can only be repealed by explicit wording in the subsequent law. And since the Weights and Measures Act of 1985 did not explicitly repeal the European Communities Act of 1972, it could not have been taken, could not be taken to be invalid against it. So the question is, was it correct, however, for them to say that the European Communities Act, 1972, was a constitutional statute? Because when it was passed, they all shouted themselves hoarse to say it was not constitutional. And I want the opinion of John Bingley on this. Was the ECA 72 a constitutional statute, and does Parliament have the sovereign power to repeal it? Right. That's his understanding.
For those of you that don't know, this is Torquil Dick Erickson, who Nigel referred to earlier today as the chap who first uncovered the corpus juris case back in 1998. Thank you, Torquil. John.
Yeah, well, there's a very interesting point there. In the case, Judge Morgan was overturned by Lord Justice Laws's comments. And Lord Justice Laws, as Torquil has said that there can be no implied repeal of constitutional statute. This is an interesting area, and it's a bit complicated, but in essence it's fairly simple too, so that doesn't sound very good, does it? But what happens is that I believe that what laws did was to say, well, we have actually, the common law has now recognised that there is a category of constitutional law. Well, I think the Bill of Rights was constitutional for an entirely different reason. It wasn't in a special category of its own, specifically. We had a Declaration of Rights, which I explained, and you've seen the copy of. And we also had a statutory form saying, which cites, as I explained in the Bill of Rights, it cites the Declaration. And its job was telling the Crown on what terms it may govern. So its purpose was to regulate the prerogative of the Crown. And that is what it ought to do, and I believe has done, and can do again. I don't think we've lost it, and I don't think we want to lose it. We want to hang on to every word of it. It's a very wonderful document, and very cleverly drafted. It's worth noting that Hampden was on the council of the people. There were 39 lawyers who helped draft this Declaration of Rights, and anybody that's interested in reading it, it is worth studying. It's fascinating. But the purpose, the reason that it was, the Bill of Rights was constitutional, was because the Crown had been handed over by the Declaration, and the Bill of Rights was merely this statutory enactment to confirm and establish with the force of statute law all that was taken forward by the Declaration and the settlement of the Revolution. That held till modern time. So to say that the Bill of Rights, for instance, if Parliament were today to pass a bill for torture, terrorists will be, or blue-eyed babies tomorrow can be murdered because we've got too big a population. And this is a sort of extreme example of a law. We just take an extreme example to illustrate the principle. So Parliament can pass such a law. Well, how can the Crown assent to it if it's regulated by law that says that it can't create cruel and unusual punishment? Implied repeal, the doctrine of implied repeal, says, oh, that's all right, Parliament is supreme. All it need do is pass the new law, and then for the purposes of the new law, the new law impliedly repeals the cruel and unusual punishments. Well, of course, it's nonsense if you realise how Parliament is set up and that the power still is vested, technically at least, with the Crown. At law, it is vested with the Crown. The documents that you've seen are the latest. There's no newer documents to impliedly repeal our Bill of Rights in that way. So the Bill of Rights is constitutional, and it's entirely because of its content and what it was about. To call the ECA 72 a constitutional statute, well, yes, it is constitutional in a way as it altered some aspects of things, but it wasn't constitutional in as much as it was commanding the Crown and what the Crown could do and what the Crown's powers were. And how could it do it? How could for instance, the Privy Councillors who have that oath of office, and there were definitely, if you go to the Privy Councillor's website, I went there just a few days ago, and you can look up that oath of office, and it's still there to be found. So I assume that they're all swearing the same oath of office, and they certainly have been through all these Lisbon Treaty and so on. So it stems from medieval times to today that they won't allow anything against, to interfere with the preeminence of the Crown. Okay. So it's a very interesting thing. I hope that answers it for you. I don't know how you can. The two things are constitutional for different reasons. But I think it can be perfectly ordinarily repealed. It's just an act of Parliament. And the ECA 72 ought to be fully repealable by ordinary statute law.
One last question. It's 7 o'clock. There is a chairman's dinner or buffet this evening, which I'm going to, I'm sure a number of you are. But you sir at the back, had your hand up first, if I can take your question.
Yeah, it's actually two questions. Is it still open to launch a prosecution on this basis? Since the other one on legitimate expectation was the one that actually went before.
The case is finished. It's closed.
That case is finished.
Yes,
This logic still applies.
Oh, does this law...
Does constitutional approach?
Well, so far as I'm aware, from what I've been told, there would be the opportunity to mount a case down the constitutional route. The problem is, having lost one, which has run into probably 7 figures, the cost, which Stuart Wheeler will be lumbered with, it's a question of finding a very brave multimillionaire who's prepared to mount a second challenge. So far, none have volunteered. But if you can find one, we'll call council's meeting again.
I understand that. I wanted to understand whether it was possible legally.
So far as I'm aware, it is.
And since the Stuart Wheeler case ended up on legitimate expectation, I was expecting out of that to get a view that manifesto promises either meant nothing legally or did mean something legally. It never quite got to that point.
Well, as Nigel said immediately afterwards in his press conference, that politicians' manifesto promises aren't worth the paper they're written on. And clearly, we can see that that's the case in law now.
Well, that's what I was questioning, what the legal position was now on manifesto promises.
Well, no one's yet challenged that, but it remains to be seen.
I think if I'm sort of finding it difficult to hear you, but I think you were asking, could further legal challenge be mounted against the Lisbon Treaty? I think that if it goes further, yes, I think it could. What we have, we've never had a Marbury versus Madison. We've never had our judges declare a law unlawful. This is a huge step for them. They all believe that this isn't their job. Well, if you've got constitution, surely if constitutional bounds are broken, the people must be able to go to the courts to get the invalidity of the intrusion over the boundary to be put right, and that may mean calling a law unlawful. And certainly within the Countryside Alliance case, there is some discussion on that, and so the people are aware of it. The politicians, of course, don't want to talk about it because they lose power and authority.
Isn't there somebody like an official solicitor whose job is to look after the interests of the people in situations like this? Or a constitutional body that would fund and take an action?
Yeah, I mean, I think there could be, one of the things that I've dreamt of is that one could start up somehow, if one could get 100 million quid together into a pension fund. And after all, this sounds a phenomenal amount of money, but in city terms, it isn't. And if a huge pension fund could be put together, instead of all these court cases as we do, going around cap in hand all the time to say, oh, well, can we get so-and-so to help with this, or, pass the hat round to all these audiences, and then the money gets spent on the lawyers again. If ever a big capital sum could be put into an account and properly managed, it could be there as a protective, like a pension fund, so that when the issues arise, there would be funding, and it could do it all out of its interest, and ultimately repay the donors as well. And it strikes me that such a fund ought to be built, and that's one of the things I originally approached Stuart Wheeler about, was to look at the possibilities of going that way and be diversified.
Don't think he wants to go down that route just at the moment.
Yes, well, quite. It's a huge amount of money, but it's in corporate terms, it's very small.
Right. John, thank you very much for coming. Thank you for the speech you gave us. I'm sure you found that interesting, ladies and gentlemen. Yes. Thanks for staying back to listen to it. Good night.